Welcome back. In this video, we're going to explore 20 of the most important vocabulary terms in corporate law, all explained clearly and used in real legal context. Whether you're a lawyer, a law student, or business professional working in English, these are terms you'll hear in boardrooms, contracts, meetings, and even courtrooms. Here's how it works. Each term will appear on the screen with a clear definition and example, and I'll walk you through what it means, how it's used, and why it matters. And at the end, I'll read you a short story that uses most of these terms in context, so you can test your comprehension and deepen your understanding. A shareholder is a person or entity that owns shares in a company. These shares represent a legal ownership interest. Let's look at the example. Shareholders vote on important decisions and receive a portion of profits. Exactly. Shareholders have certain rights depending on the type of shares they hold. This usually includes the right to vote on major corporate matters, such as electing the board of directors or approving structural changes like mergers. In many cases, shareholders are also entitled to receive dividends, which are distributions of the company's profits. So, being a shareholder means more than just investing money. It means having a formal role in the governance and success of the company. Incorporation is the process by which a business becomes a legally recognized entity or corporation. It involves filing the necessary documents, usually articles of incorporation, with the appropriate government authority. Now, let's read the example. The company completed its incorporation in March and is now fully registered. Once incorporated, the business becomes a legal entity. That means it can enter into contracts, open bank accounts, and operate independently of its owners. It also marks the beginning of many legal protections, like limited liability. Liability refers to the legal responsibility for something, typically debts or damages. If a company is liable for something, it means it is legally obligated to fix it, pay it, or take responsibility for it. Let's read the example. Incorporating a business protects the owners from personal liability. This is key. When a company is incorporated, it becomes its own legal entity. So, if the business is sued or goes into debt, the owner's personal assets, like their home or bank account, are generally protected. And that's what we mean by limited liability. The board of directors is the governing body of a corporation. They are elected by the shareholders to provide oversight, strategic direction, and accountability for the company's management. Here's an example. The board of directors met to approve the company's expansion plans. That's a common role for the board. They don't usually handle day-to-day operations. That's up to the executives and workers. But they do make key decisions about growth, governance, and compliance. They represent the interests of the shareholders at the highest level. Bylaws. Bylaws are the internal rules that outline how a corporation runs. They cover procedures for meetings, voting rights, officer duties, and much more. Let's take a look at the example. According to the bylaws, board meetings must be held every quarter. That's exactly the kind of rule you would find in corporate bylaws. While laws regulate corporations from the outside, bylaws are how the company organizes itself from the inside. They provide structure, consistency, and a legal framework for corporate governance. Dividend. A dividend is a distribution of profits to shareholders. It's one of the main financial benefits of owning shares in a company. Let's look at the example. The corporation issued its first dividend this quarter. Not all companies pay dividends, especially in the early stage or fast-growing companies that reinvest profits. But when a business is stable and profitable, dividends are a common way to return value to shareholders. Merger. A merger happens when two companies combine to form a single new entity. This is usually done to create economies of scale, expand into new markets, or increase competitiveness. Now, the merger created one of the largest tech companies in the region. Mergers can be friendly or hostile, and they often involve negotiations, shareholder approval, and government regulation, especially if competition is affected. Acquisition. An acquisition is when one company takes over another by purchasing all or most of its shares or assets. It's different from a merger because in an acquisition, one company remains in control. Here's the example. The startup was acquired by a global financial firm. This happens a lot in tech, where small, innovative companies are bought by larger corporations looking to expand or stay ahead of the market. CEO, or Chief Executive Officer. This is the top leader in a corporation. They're responsible for making major decisions. They manage overall operations and execute the board's strategic vision. Let's read the example. The CEO is responsible for implementing the company strategy. In practice, the CEO leads the executive team, communicates with stakeholders, and serves as the public face of the company. They are accountable to the board and ultimately to the shareholders. Corporate governance. Corporate governance is about how a company is managed, monitored, and held accountable. It includes everything from the board's responsibilities to ethical guidelines and transparency. Here's the example. Strong corporate governance builds investor trust. Good governance promotes stability, protects shareholder rights, and ensures compliance with the law. It's one of the key reasons investors feel confident putting their money into a company. This one is a tongue twister. Fiduciary duty. A fiduciary duty is one of the most serious responsibilities under corporate law. It means you must prioritize another person or entity's interests above your own, often involving trust and care. Let's read the example. Directors have a fiduciary duty to act in the best interest of the company. In practice, this means that directors can't use their position for personal gain or make careless decisions. They must act honestly, carefully, and in good faith for the benefit of the corporation and its shareholders. Quorum. A quorum ensures that decisions aren't made by just a few individuals. It's the minimum attendance required for a board or shareholder meeting to be valid. Here's the example. Without a quorum, the board could not vote on the new policy. Quorum rules are often set in a company's bylaws. If not enough people attend, No official actions can be taken. It is a safeguard for fair representation and accountability. Proxy. A proxy allows someone else to vote or act for you, usually at a shareholder meeting. It's common when the shareholder cannot attend in person. Let's read the example. Many shareholders voted by proxy at the annual meeting. Proxies are essential in large corporations where investors are scattered around the world. They allow key decisions to move forward while still respecting shareholder rights. Stock is a fundamental concept. It is a unit of ownership in a corporation. When you own stock, you own part of the company. Here's the example. She invested in stock from several multinational corporations. Stockholders may receive dividends and have voting rights, depending on the type of stock. Common stock and preferred stock each come with different benefits and risks, but both represent a legal stake in the company. Capital. Capital refers to the financial resources a business uses to operate, grow, or invest. It could come from investors, loans, or personal funds. Let's read the example. They raised capital to expand into new markets. Businesses raise capital in various ways, selling stock, borrowing money, or reinvesting profits. Without capital, a company cannot grow, innovate, or even stay afloat. Legal entity. A legal entity is a business or organization that can enter contracts, own property, and be held liable, all under its own name, not the owner's. Let's read the example. Once incorporated, the company became a separate legal entity. This is a core concept in corporate law. It means the business exists independently of its founders. If the company is sued, it's the entity, not the individual, that's responsible. That separation is what makes incorporation so powerful. Insolvency. Insolvency means a business can no longer meet its financial obligations. It's a warning sign that the company may be headed toward bankruptcy. Here's the example. The company filed for insolvency after several quarters of losses. This happens when a company owes more than it owns or can't pay bills as they come due. Insolvency can lead to restructuring, liquidation, or formal bankruptcy proceedings, depending on the jurisdiction. Compliance. Compliance means obeying the law. Simple as that. In a corporate context, it refers to how well a company follows local, national, and industry-specific rules. Let's read the example. Companies must ensure compliance with labor and tax laws. Compliance covers everything from data protection to anti-money laundering to corporate governance. Failing to comply can lead to fines, lawsuits, or reputational damage. So it's a major focus in corporate operations. Minutes. Minutes are the written record of a meeting. Who attended, what was discussed, and what decisions were made. They are essential for accountability and legal clarity. Here's the example. The board secretary distributed the minutes after the meeting. In corporate law, minutes serve as evidence that the company followed proper procedures. They're often required for audits or legal disputes, and they help keep the directors and shareholders aligned. And the scariest word of all, audit. An audit is a deep review of a company's finances to check accuracy, transparency, and legal compliance. Let's read the example. An external audit confirmed the company's financial statements were accurate. Audits can be internal or external. External audits, especially those required by law or shareholders, give credibility to financial reporting. They're essential for investor trust and corporate transparency. Let's take a look at the TV show Succession. It's a story full of corporate law in action. At the center is Waystar Royco, a giant media company. The founder, Logan Roy, is both the CEO and controlling shareholder, and the show revolves around his children fighting for control of the company. When Logan becomes ill, the board of directors meets to decide who should take over. But there's a problem. Some members vote by proxy, and they barely reach a quorum to make a valid decision. Meanwhile, the company's bylaws, those internal rules, become critical. They outline what happens if a CEO steps down and how fiduciary duties must be held. In Season 2, Waystar faces a scandal. The board considers declaring insolvency to protect the parent company from liability. But Logan refuses. He wants to maintain control and keep paying dividends to the family's holding company. Later, there's talk of a merger or acquisition by the tech giant called Gojo. Negotiations begin, but the Roy family cannot agree. Some want to protect the family's capital and reputation, while others just want to sell their stock. Every move is recorded in board minutes, and lawyers are constantly ensuring compliance with regulations. At one point, documents are marked confidential, and the threat of legal liability hangs over the entire family. It's corporate warfare, but it's also a goldmine of real legal English. And so that story we just told, look at all the vocabulary we used naturally. Shareholder, CEO, board of directors, proxy, quorum, bylaws, fiduciary duty, insolvency, dividend, merger, acquisition, capital, stock, minutes, compliance, liability, and confidential. So, great job completing this lesson. You've now learned 20 essential corporate law terms that will help strengthen your professional legal English. To make these words truly yours, keep reviewing and practicing them in your daily work, whether in emails, meetings, or client discussions. The more you use them, the more natural they'll feel. Try creating your own sentences or brief scenarios using these terms. Repetition and real-world application are the best ways to build confidence and fluency. Thanks for watching.